कंप्लीट हेल्थ इंश्योरेंस, टेंशन नहीं, इंश्योरेंस लीजिए।
Hello and welcome to Bloomberg Quint. You're watching the fine print. A contract of guarantee is a contract to perform the promise or discharge the liability of a third person in case of his default. With over 500 companies facing insolvency proceedings, guarantees issued by their promoters or group companies have become the center of debate and litigation. Can beneficiaries invoke guarantees given by companies facing insolvency proceedings once the process has started? Can guarantees given by promoters of insolvency companies be invoked? Can beneficiaries move against both the guarantor and the borrower? There are no clear answers, and conflicting rulings by courts haven't helped the cause of guarantees either. The fine print spoke to insolvency lawyers to get some answers. The first scenario that has been playing out before various NCLTs is where a company has been admitted for insolvency and a corporate guarantee was invoked after that. A peculiar situation arose in the Educom Solutions and EduSmart Services case. Both companies were facing insolvency proceedings, and Axis Bank chose to submit a claim against Educom Solutions for the loan amount and against EduSmart Services as a beneficiary of the guarantee for the same loan. In October last year, the Delhi bench of the National Company Law Tribunal denied Axis Bank's action against EduSmart Services, saying that once a company has been admitted to the insolvency process, a corporate guarantee cannot be invoked against it. The tribunal pointed out that a corporate guarantee invoked after insolvency proceedings have started would defeat the purpose of the moratorium, that is, the period during which all legal proceedings in relation to the company and its assets stand abated since it's facing insolvency. The Kolkata bench took a similar view in the case of MBL Infrastructure.
See, the provision for a moratorium is essentially against actual proceedings or against actual litigation in a sense. The act of invocation of a guarantee is not subject to a moratorium, because you can always notify the guarantor, or there could be a concept of a deemed claim, because all guarantees are ultimately subject to default of the principal debtor. The very fact that the principal debtor has been subjected to a proceeding under the IBC because he is staring or facing insolvency action and therefore needs a resolution is an admission of default. And because it's an admission of default of the principal debtor, it is equivalent to a deemed default of the guarantee. And whether or not a notice is issued or not, the fact of the matter is that because there is an action pending in the CIRP, the guarantee is effectively in a situation where default has already occurred, and therefore action against the guarantor is something which can commence, and a claim can be filed in the action in relation to the principal debtor as part of the CIRP if it's an unsecured guarantee, and even if it is a secured guarantee, it can always be subjected to the filings required under the CIRP process.
I don't believe that Section 14 is trying to stop contractual rights from being invoked at a time when the company is in a resolution process. In fact, the important thing in the resolution process is to understand exactly what the IBC company's liabilities are and deal with them. Now, on the one hand, if you say that you're not going to allow the invocation of a guarantee after insolvency commencement date, what is going to happen to that guarantee after the completion of the resolution process? Can that guarantee be invoked then for the full amount, for a partial amount? So there's uncertainty not only for the guarantor, but also for the company and also for the new investors. And I think therefore uncertainty all around, which I don't think is the aim of the resolution process at all.
As a result of EduSmart Services ruling, beneficiaries of guarantees have not just been prevented from invoking them once the insolvency process has started. They've also been denied the right to submit their claims if the corporate guarantee was not invoked before the insolvency process started, a view that was also endorsed by the Kolkata NCLT in the Binani Cements case. The tribunals held that if a demand hasn't been raised on account of a corporate guarantee before the insolvency process has started, no proof of claim can be submitted later on. They concluded that the debt becomes due after the invocation of a corporate guarantee, and if this is done at a time when the insolvency process has already started, there won't exist a record to verify such a claim.
The guarantee, if invoked, would be invoked in favor of the debtor, which in favor of the guarantor, which itself is facing insolvency. And thus, if you allow a fresh claim or filing of claims, proof of claims, etc., in those cases, then it would fundamentally alter the assets of that guarantor, which in its own case is a corporate debtor. So 14(1)(c) would be violated, and thus, I believe the judgments passed in these cases would be fair and correct.
I think that's unfortunate because the corporate insolvency resolution process regulations actually have a specific regulation which requires the resolution professional to make an estimate of just these kinds of claims where an invocation has been made after an ICD, and this is assuming, of course, that we agree with the previous judgment would say that you cannot invoke a guarantee after ICD. Assuming that to be correct, I should still be able to submit a proof of claim saying there is a guarantee I benefit from this corporate debtor, which is a contingent claim. And the resolution professional should be able to estimate that claim on the basis of the facts available at the hand of the resolution professional. In this case, where a guarantee has been invoked after ICD, even assuming that the case law is correct that you can't, the guarantor should therefore be entitled to the full amount, really, and the resolution professional should be in a position to estimate the full amount of the guarantee and admit that as part of the process. If he doesn't, one, what does that regulation 14 of the CRP regulations mean really? What is it trying to say when it requires the resolution professional to make an estimate of just these kind of contingent liabilities?
When the committee of creditors is constituted, it is based on all those persons who have filed their status and value owed to them as financial creditors. The definition of financial debt includes a guarantee very specifically. So, and therefore, consequentially, guarantors are they are covered. The people, beneficiaries, are covered as financial creditors by IBC. That being the case, because I am a financial creditor, and the logic which is now being sort of argued before the tribunal, that this is a deemed claim and a deemed default, the matter of excluding the guarantees or matter of not consider them as invoked is probably a wrong view.
In all these cases, Edu Smart Services, Binani Cements and MBL Infrastructure, it's the guarantors who are facing insolvency proceedings. But what happens in cases where third parties, such as group companies or promoters, have given guarantees for a company that is facing insolvency proceedings? Courts have given different rulings on this aspect as well. In the Phoenix ARC and Alpha and Omega Diagnostics rulings, the National Company Law Appellate Tribunal held that guarantees can be invoked against third parties even if the company in whose favor the guarantee was given is facing insolvency proceedings. That is, the moratorium under the Insolvency Code cannot be extended to the assets of guarantors of the corporate debtor. A contrary view was taken by the Allahabad High Court that disallowed proceedings against the guarantors while the corporate debtor was under the insolvency process.
There was a judgment in Allahabad which was passed by Allahabad High Court late last year. But I believe the factual situation in that particular case was a bit different. Allahabad High Court also had to opine that the crystallization of liability hasn't yet happened, and the invocation and whether in such cases the invocation should be allowed or not. So the fact situation was a bit different, but yes, there was a contrary judgment passed by Allahabad High Court. But in my view, the judgments passed by NCLATs in both these cases should be fair understanding of 14(1)(c).
My view is, the way it is emerging is that the action against the guarantor is independent of the action against the principal debtor, and merely because there is a moratorium against the principal debtor does not mean that there is a moratorium of the guarantee. especially if it is a corporate guarantee or even if it is a personal guarantee, for two reasons, as I mentioned, that if you look at the SICA law, the law had to be amended to include or extend the principles of the moratorium to the guarantor, which is not the case in the IBC. So, in my submission, I feel that there is no automatic moratorium against the guarantor and certainly not against an individual, because an individual is not subject to insolvency law as yet. It has not been notified for the purpose of personal insolvency or firm insolvency, and the rules have also not yet been promulgated. The notification has not happened. So, in the absence of anything to do with a moratorium on individuals, the law is open. The law enables parties to proceed in relation to the action. Nothing in the law says that I must take action first on the principal debtor and only then take action against the guarantor. No law says that.
Beneficiaries of guarantees have been taking another recourse to get borrowers and guarantors to pay. Initiate insolvency proceedings against both of them. Here too, the outcome has been mixed. In Visa Steel, the company had given a corporate guarantee for Pelogic's infrastructure in favor of ICICI Bank. ICICI Bank sent a demand notice to Pelogic's infrastructure and a letter of invocation to Visa Steel. When it failed to receive its dues, ICICI Bank initiated insolvency proceedings against Pelogic's infrastructure and during its pendency also filed an insolvency application against the guarantor, that is Visa Steel. The Kolkata bench of the NCLT denied ICICI's application against Visa Steel on grounds that a creditor cannot bring an insolvency action against both the guarantor and principal borrower. But the Ahmedabad bench took a contrary view in PCC Estate and allowed IDBI Bank to initiate insolvency proceedings against both the guarantor and principal borrower.
I would humbly go with the view taken that you can only invoke insolvency against the corporate debtor, and in that case you should not invoke insolvency against the guarantor. Because I think it was rightly decided in that judgment that if you invoke guarantees, if you invoke insolvency against both the debtor as well as the guarantors, then effectively you are jeopardizing the rights of the other creditors in the case of corporate guarantors. First, and second, you are also, if you are taking a benefit of both the insolvencies, then effectively you will be, you probably may end up getting double the benefits or double the recoveries in this case. And thus, if there is invocation of insolvency which has already happened in the case of debtor, in my view, you should proceed with that. It would only be fair to only invoke corporate guarantee, and if the corporate guarantee is defaulted, then not to invoke insolvency against the corporate guarantor simultaneously.
Basically, the filing of a CIRP by the principal debtor is admission of default, admission of inability to pay, and therefore the covenant of the guarantee is equally breached. I can, as I said, in a civil proceeding, I can file two actions. I can file an action against the principal debtor. Independently, I can file an action against the guarantor. If that's the provision in Indian civil procedure as part of action against mortgages or actions against guarantees, the same will apply to an insolvency proceeding. I can file an insolvency against the principal debtor. I can file an insolvency against the guarantor, assuming that both have a disability or inability to pay. And I will be member of the committee of creditors in both, subject to the principle that I cannot recover more than 100% of my value. I can't double dip. Say, for example, if I get 20% from my guarantee, the guarantor pays me 20% as part of the CRP under the guarantee case against the guarantor company, and the principal debtor pays me 90. I have to refund 10 to the guarantor, because I can't get 110. I can maximum get 100% of the value. So that's the overriding principle. You can't double dip.
Well, so that's what happened in Sanjeev Shriya, right? In Sanjeev Shriya, what the guarantee beneficiary SBI was doing, it was proceeding against them in the DRT. And the Allahabad High Court said you can't proceed for that civil remedy in the DRT. You can't make a recovery until you complete the IBC process against the principal debtor on two counts, actually. One, that the amount to be paid by the guarantor is uncertain, and potentially that it's a breach of the moratorium, because as in when you do make a recovery from the guarantor then benefits by rights of subrogation from the security you benefited from. And that movement of security from you to the guarantor is effectively a breach of the moratorium of the principal debtor. So actually both routes are crammed down right now for lenders. Recovering in a civil suit in the DRT, or as the case may be, or filing an IBC application.
Well, the issue of guarantees promises to get hotter in days to come. The appellate tribunal has reserved its order in the Edu Smart Services case. Once that order is in, it will perhaps clear some of the fog around the issue of guarantees. Moving on. After 11 years of litigation, the Supreme Court has upheld market regulator SEBI's order to say that synchronized trades in the futures and options segment amount to unfair trade practice, a view that's contrary to that of the Securities Appellate Tribunal. But in recognizing this principle, the Apex Court also concluded that the brokers who facilitated these trades didn't do any wrong, and that SEBI hasn't done enough to prove otherwise. So has the Supreme Court ruling expanded the scope of unfair trade practice? And what burden of proof will the market regulator need to discharge in future cases? The fine print put these questions to securities law experts.
Back in 2007, market regulator SEBI had found 3 traders guilty of unfair trade practices. The allegation was that these traders indulged in synchronized transactions in the futures segment, where one party booked profits and the other party booked losses. Subsequently, SEBI had found that the trades were reversed in all the cases in a matter of few seconds, showing significant difference between the buy and sell trade prices. Further, the change in positions took place with negligible change in the price of the underlying security. 3 brokers, India Bulls Securities, Angel Capital and Prashant Patel, who had facilitated these reversal trades, were also found guilty of SEBI's regulations for stockbrokers.
To my mind, the modus operandi for these trades were that the party and the counterparty to most of these trades were identical. The trades were carried out within a matter of seconds or probably hours, and they were reversed on the same day within a few seconds of the hours. But there was a significant price gap between the buy trade and the sell trade, which was not necessarily in line with the then existing market price. There was no settlement of accounts at the end of the day between the 2 parties to the contract. And the most critical aspect, which seems to have been the clincher in this situation, is that there was no transfer of any beneficial interest in those securities.
The crux of SEBI's allegations was that the parties were buying and selling securities in the derivative segment at a price which did not reflect the value of the underlying in synchronized and reverse trades carried out by them. This, the market regulator had said, amounts to unfair trade practice. But the Securities Appellate Tribunal had disagreed.
The tribunal had noted that SEBI's allegation is that by executing manipulative trades in the F&O segment, Nifty index was sought to be tampered with. SAT pointed out that this argument is too far-fetched to be accepted. In its order, the appellate tribunal had explained that Nifty index is a very large, well-diversified portfolio of stocks which is not capable of being influenced, much less manipulated, by the movement of prices in the F&O segment, particularly by a handful of trades. Looking at the timings of these trades, SAT had concluded that the arrangement between the parties was that profits and losses would be booked by each of them for effective tax planning, and it is for this reason that they had synchronized the trades and reversed them. And so it concluded that synchronized and reversed trades that have not resulted in manipulation of the market or change in beneficial ownership and done for the purpose of tax planning cannot amount to unfair trade practices. As for the allegations against the brokers, the Securities Appellate Tribunal had held that they had merely carried out the directions of their clients and that the anonymity of the trading system does not allow a broker to know who the counterparty or its broker is.
Yeah, I would completely agree with the set conclusion and the observations as also the order, because there has to be some manipulation in the market which affects the investors or the market at large. Here in these types of trades, the market was not affected, the investors were not affected, there was no manipulation which was demonstrated, and therefore even if it is a synchronized trade, to my mind it is not in breach of FUTP. There has to be a result of that synchronized trade.
First and foremost, in a synchronized trade, intention is implicit. What SAT has actually done is it has actually stepped away from its earlier decision in the Ketan Parikh's case, where it, amongst the other criteria that it had laid down, one of the criteria was that in the event that there is no transfer of beneficial interest, such a transaction or a trade would be deemed to be manipulative of the market. Now, we don't really need to go that far. Even if we look at regulation 4.2a and b of the PFETP regulation, there itself there are certain criteria laid down, one of which is that there has to be a transfer of beneficial interest. If it is not, it will be deemed to be manipulative of the market.
Now, after 8 years, the Apex Court has overturned the Appellate Tribunal's ruling to say that intentionally trading for a loss is not a genuine trade.
The Apex Court has pointed out that if one party consistently makes losses, and that too in pre-planned and rapid reverse trades, it is not a genuine but an unfair trade practice. The Supreme Court has explained that the trade reversals indicate that the parties did not intend to transfer beneficial ownership, and through these orchestrated transactions, other investors have been excluded from participating in these trades. Further, the fact that when the trades were not getting synchronized, the traders placed orders at unattractive prices is also a strong indication that they intended to play with the market.
The Supreme Court, to my mind, has gone on the basis of market integrity and market abuse, and not as to whether these transactions per se were manipulative in nature and therefore fraudulent and therefore in breach of FUTP. Merely because there were huge gains or huge losses on that particular trade, merely because there was no transfer of beneficial interest, would not mean that the parties have entered into a fraudulent practice or have manipulated the market.
The PFETP regulation itself doesn't stipulate anywhere that only if there is any harm that is caused to the capital market would there be deemed to be a violation of the PFETP regulations. There are certain criteria laid down. If the trades fall foul of those criteria, irrespective whether there is a harm to the capital market or not, it will be deemed to be violative of the PFETP regulation, which is what has happened in this case. The clincher being that there were no transfer of beneficial interest and there was no settlement of accounts at the end of the day, and the trades were reversed on the same day, and the reversal were at a price which was significantly higher than the then prevailing market rate.
The way I see it is that as we speak, the SEBI has already constituted the Vishwanathan committee to look into the fair market conduct aspects of the securities market, and I am sure they will take cognizance of the observations made by the Supreme Court in its order. And in fact, the way I look at it, it will in fact give more handle to SEBI as from an investigation perspective, and it will bolster SEBI's position going forward, including all the ongoing matters.
But at the same time, the Supreme Court has dismissed SEBI's allegations against the brokers on lack of evidence that suggests negligence or connivance. The court has said that merely because a broker facilitated a transaction, it cannot be said that there is a violation of the regulations.
They've also discussed in this judgment the fact that a broker typically doesn't go behind the orders of a client And when a client places the order, a broker presumes that the order is kosher and they carry out the trade. So essentially, in view of the lack of evidence, they have let the brokers off.
Well, that's all that we have on this week's show. Thanks so much for watching. We'll see you next week.